Welcome. In the middle of a strata dispute, does it ever feel like you're playing a game, but the other side is hiding some of the most important pieces? Well, today, we're going to unlock a really powerful, but honestly often overlooked tool in the Strata Management Tribunal's playbook. It's called Regulation 41, Interrogatories. Let's dive in and see exactly how this can help you level that playing field. So here's how we're going to break it all down. First, we'll talk about that gap in your case. Then, we'll introduce the solution, the power of interrogations. We'll walk through the application step by step, see what happens when the tribunal issues an official order, and crucially, what happens when those rules get ignored. And we'll wrap it all up with the one key takeaway you absolutely need to remember.
All right, let's kick things off with Section 1. We're going to start by talking about a really common, and let's face it, incredibly frustrating problem you might be facing in your own case.
Have you ever been in that spot? You just know there's a piece of information out there that could completely prove your point, but the other party is holding all the cards? You've got questions, but there's no official way to get them to answer. And that information gap, that can literally be the difference between winning and losing.
But what if there was a formal, legally backed way to get those answers, to bridge that gap? Well, guess what? There is. In Section 2, we're going to look at the tool designed for this exact situation. The official term is interrogatories, but please don't let that big word intimidate you. Just think of it like this. It's a formal, written interview. This isn't some casual back and forth. It's a serious legal process where the other side is actually compelled to answer your specific questions, truthfully, in writing and under oath.
And here it is, right from the source. This is where the power comes from. See, this isn't just some clever tactic. It is a right that's written directly into the regulations. The law itself says you can go to the tribunal and ask for an order to serve these questions. It forces the other side to address the key issues in your dispute. Okay, so you're probably thinking, great, this sounds useful, but how do I actually do it? Well, the process is very specific, so let's walk through the exact steps you need to take.
The whole thing is really structured. First, you have to use a specific document, Form 14, to officially file your application. Second, and this is key, you have to clearly state your reasons. Why are these questions so necessary for your case? And third, you have to attach the exact questions you plan to ask. It's all about being clear, prepared, and showing the tribunal you have a good reason.
Now, it is absolutely essential to get the two key forms straight in your head. Form 14 is the one you fill out. It's your request to the tribunal. But if the tribunal agrees with you, they then issue Form 15. And that's not a request anymore, that's the official order. Your application literally becomes a command.
And that brings us right to the next stage. So what happens once you've submitted your application and the tribunal actually makes a decision?
This is exactly where your application gets its teeth. As soon as the tribunal gives the green light, it stops being a simple request between you and the other party. It becomes a formal, legally binding order from a judicial body. Your questions are no longer just an inquiry, they're now a legal obligation.
And the regulation is super clear about this. The order is issued on that Form 15 we just talked about, and the tribunal can set specific terms. What does that mean? It means they'll be the ones to dictate the deadline for the answers and any other conditions they think are necessary. It just adds another layer of seriousness to the whole process.
Right, but what if the other party just decides to ignore it? What happens when a direct order from the tribunal is just completely disobeyed?
Let me be crystal clear here. This is not some optional homework assignment. The regulations already thought about this, and they've built in some very serious consequences. Choosing to ignore a Form 15 order is a massive strategic mistake, and it comes with very real penalties. And those consequences are severe. If you're the one who is supposed to answer and you don't, your entire claim could be thrown out. Your whole defense could be struck from the record. The tribunal can basically just decide the case against you right then and there. This is the enforcement power that makes sure interrogatories are taken seriously.
Wow, we've covered a lot of ground. So let's bring this all home and really focus on the big picture. Why does any of this actually matter to you? When you boil it all down, Regulation 41 is really about two things: fairness and truth. It's an incredibly powerful tool to uncover facts that you're missing, and it gives you a formal, court-approved process to do it. It stops one side from just hiding information, and because the consequences of ignoring it are so serious, it guarantees the process is respected. It's a real game changer.
So I'll leave you with this to think about.
Now that you know this tool exists, now that you know you have this legal right, what is the one crucial question, the one piece of information that if you could get an answer to might completely change the outcome of your case?